All right, welcome. Mike normally moderates these things, so it became kind of a question of what's he going to do with his own book celebration, and I actually asked to do it. I thought the book was terrific and kind of horned my way into it, so I'm going to be the moderator. I'll say a few things for a few moments, but mostly just get out of the way and let our guests speak. I want to first introduce our guest presenters. You know Sherry and Mike. Our guests in order here are Deborah Tuerkheimer, who is a professor of law at Northwestern. She is a scholar of criminal law, feminist jurisprudence, and evidence. She's written a number of important, very influential articles on rape and consent and the campus rape crisis. She is also a co-editor with our own Cynthia Bowman, who I think I just saw coming in, of a textbook on feminist jurisprudence. And she's here from Northwestern. Our other speaker is Mylan Engel Jr., who is a professor of philosophy at Northern Illinois University. He writes on epistemology, philosophy of religion, and ethics, and has a special concentration in the area of animal rights. He actually has a whole separate animal rights ethics vita, which is extensive and full of many publications and edited volumes on animal ethics. They will be speaking for about 20 minutes, and then Sherry and Mike will respond. People have to leave for classes and things like that, so that's fine. We know that. So we'll try to move things along. Before getting into the substance of the book and the arguments and why I find it so engaging, I just wanted to really single out the book as a model of scholarly virtue. I know it's an old-fashioned word, virtue, but I use it advisedly because this is a book about ethics, and I want to invoke the ideal of academic ethics. And I really hope that all of us can aspire to and actually to be as fair-minded, careful, and non-polemical as Sherry and Mike are in this book. They obviously care very deeply about the subject, but ironically, that can sometimes make it more difficult to be as rigorous at making and evaluating one's own arguments. And it may be useful to add the perspective of an outsider here, as I am, to the animal rights movement. So for me, reading the book wasn't like reading a political commentator you agree with and going, yeah, give him hell. It wasn't like that at all. I was reading and going, yeah, well, gosh, that's a good point. I better think about that. But what's really illuminating about reading the book is that Sherry and Mike give the impression that they did that for both sides. That as they were taking their own arguments and counter-arguments seriously, they were saying, wow, gosh, that's pretty powerful. I better stop and think about that. And they write like that. And so the experience of reading the book is really the experience of being led through an extremely fair and careful, rigorous argument for their positions, which again, there's something wishy-washy about the book. They believe very strongly in what they're saying, but they do it in an extremely careful way. As someone who's interested in moral theory, I read and write on the subject, I wanted to make the pitch that the book has considerable significance beyond the animal rights and reproductive rights communities, and goes beyond the extremely interesting issues that it addresses. It talks about animal rights and abortion, and as well as perennial issues in ethics such as the act-omission distinction, but it also touches on more general concerns such as the virtues of incremental and maximal strategies in public ethics, principled and pragmatic reasons to refrain from the use of graphic imagery and violence, and conditions for the efficacy of social movements. They also talk about what to me is one of the most important issues in political ethics, which is the scope of moral demands in a non-ideal world, which is to say, a world in which animals have already been selectively bred for exploitation by humans, and not every pregnancy is planned or wanted. The fundamental argument in the book is that Sherry and Mike are seeking to displace reasoning, rationality, or moral agency as the criteria for something being an object of moral concern, and to replace it with sentience, that is, the capacity to experience pleasure or pain. Now, animals are generally believed to lack rationality or agency in the relevant sense, so they fall below the moral radar, so to speak. Fetuses are generally thought to have moral worth not because they can reason, but because they have the potential of developing into reasoning beings. But if the criteria for moral concern shifts from agency or rationality or humanness to sentience, it risks undermining pro-choice commitments of a supporter of animal rights, because at some stage of development, fetuses are capable of experiencing pain. Thus, it seems that a pro-choice animal rights proponent has to thread the needle, giving a theoretical account of why animals have moral worth, which does not apply to fetuses. As Sherry and Mike point out, however, identifying something as having moral worth is only the beginning of the analysis, not the end, and the rights of others must also be taken into account. In some circumstances, the mother's right not to be conscripted into providing life support services for a fetus may have priority over the fetus's rights. On the other hand, there are few situations outside of true self-defense and maybe a few truly exceptional medical experiments in which the exploitation of animals as a means to human ends is justified. And so for me as a moral theory person, the question is, why is reasoning or agency so central? Why is that usually taken to be the ground for regarding some being as an object of moral concern? And the answer is generally that we're all still struggling in the field of moral philosophy with Hume's is-ought gap. As Hume might put it, the fact of animal suffering is just that, a fact. And it's not clear how a fact is supposed to create a reason for action. Facts bear on theoretical, not practical rationality. Hume's problem may also be restated as the G.E. Moore open question argument, which goes something like this. With regard to whatever property one offers to explain good, it's still coherent to ask, yes, that I see this thing has that property, but is that thing genuinely good? Ought I to regulate my life in accordance with that in some way? Whatever property we look to as counting something as making good has to count in virtue of some connection with human characteristic interest or needs, and as well as what we expect to get out of morality, such as regulating the interactions of persons in society, telling us how to live a good life, being connected with action, and so on. And generally this has been cashed out as an appeal to human interests and desires. Now, someone like Peter Singer famously says this is just a pure prejudice. He calls it speciesism. It's nothing more than a prejudice, not really an argument. And maybe he's right about that. But I think it's worth just to very briefly set the stage by looking at a couple of positions in mainstream moral theory and the centrality of agency to those positions, just to give you a sense for the target of the arguments in Sherry and Mike's book. So modern Hobbesians, like David Gautier, understand morality as something that is in all of our interests collectively. It's essentially a solution to a massive multiplayer coordination game. And to make this approach moral rather than just prudential, there must be some constraint on the types of reasons that can be adopted as a solution to this coordination problem, and those are generally reasons pertaining to the interests of other humans. Modern Kantians, for example, Thomas Nagel, want to generalize from the situation of each reasoning agent and want it to be the case that an agent must be able to make the same practical judgment of himself or herself from an impersonal standpoint as he or she does from an egocentric point of view. That is to say, each agent must be able to endorse his or her own life plan from the perspectives of others. Again, these others tend to be human perspectives. Kant, of course, saw rational action as the end in itself, not sentience or any other theory of value. And utilitarianism, of course, can admit the suffering of animals into the utilitarian calculus. Peter Singer likes to quote Bentham on this, on the capacity of animals to suffer. It runs into a familiar problem, which is that it justifies, potentially at least, using sentient creatures as a means to the end of others. Now, of course, utilitarianism famously can be tweaked in various ways to account for this, but the difficulty in doing this explains some of the attraction of deontological morality. And finally, another kind of moral theory, contractarianism, offered by people like Scanlon, talks about an act being wrong if it is performed under circumstances where it would be disallowed by a system of rules that no one could reasonably reject. Again, taking the interests of others, taking human reasons, human agency, human rationality as central to moral evaluation. Now, all of these positions don't necessarily in principle exclude consideration of the moral concerns of animals. Bernard Williams argues that contractarianism can be tuned up to recognize a kind of trusteeship argument with respect to animals. Mylan actually sent me a really great article by someone I read and admire tremendously, Christine Korsgaard, who makes a Kantian argument for taking the interests of animals seriously. So it can be done, but ultimately mainstream moral theory has mostly focused on rationality and agency as the ground for moral concern. Sherry and Mike talk about sentience, and I think for that reason, even for people outside the animal rights community, people who may not have seen that this is something of general importance and interest, it really is. It's a terrific book. I enjoyed it and learned a lot from it, and I commend it to all of you. Put it up on the top of the Amazon bestseller list for the day. Thanks.
It's a pleasure and an honor to celebrate the publication of Sherry and Mike's terrific new book, Beating Hearts. The book is genius in its conception and in its execution, exploring the various ways in which the abortion debate and the animal rights debate interconnect and mutually inform each other proves remarkably fruitful both philosophically and practically. The book represents, and this was already suggested earlier, rational discourse at its finest. Anyone interested in either debate would benefit from reading this book. As someone who's interested in both debates, I was engrossed from start to finish. How do academics celebrate a book? By engaging critically with that book's arguments and central theses. So that's what I intend to do. The book addresses two fundamental moral questions. First question, when, if ever, is it morally permissible for humans to use or kill animals? Short answer, almost never. Question two, under what circumstances, if any, is abortion morally permissible? There is no short answer. The book also explores the following legal/social policy question. To what extent should a social democracy allocate these matters to individual conscience rather than to collective decision-making through law? Here are their more precise answers. First answer, killing animals for food and using them as experimental subjects is almost always seriously morally wrong. As such, we should refuse to support such practices and embrace a vegan lifestyle. Answer to question two, aborting pre-sentient fetuses raises no moral concerns at all. Aborting sentient fetuses that can feel pain, harms those fetuses and is prima facie wrong. Despite the presumptive wrongness of aborting sentient fetuses, some abortions may still be permissible, provided the woman has morally weighty enough reasons to justify the harm imposed on the fetus. Answer to question three, even when abortions are immoral, they should still be legal. Similarly, even though killing animals for food is morally wrong, it should remain legal given the current context in which we live. So how do they defend these claims? First, they argue that sentience, the ability to suffer, is sufficient not only for moral considerability, but for possessing moral rights, including the right not to be harmed and the right not to be killed. As they see it, sentient beings have interests and the corresponding rights needed to protect those interests. The idea that sentience is sufficient for moral considerability is relatively uncontroversial in the philosophical literature on animal ethics. The claim that sentience is sufficient for possessing moral rights is more contentious. Indeed, many people insist that in order to have moral rights, a being must be rational. But why think that? Consider the argument. X is rational, therefore X has a right not to be harmed. That's a non sequitur. What does rationality have to do with the ability to be harmed? It's much more plausible to think that the right not to be harmed is rooted in the capacity to be harmed. So here I side with Sherry and Mike. I'll be saying Sherry and Mike throughout. I was looking for a way to shorten that, but I thought S&M would be distracting. So anyway, I side with Sherry and Mike. If moral rights exist, then the right not to be harmed is grounded in the capacity to be harmed. Since sentient beings are harmed when they're caused to suffer, sentient beings have a right not to be harmed. More controversial still is the claim that sentience can ground the right not to be killed. But here again, I side with Sherry and Mike. It's plausible to think that sentient beings with a life worth living are harmed by premature death. And if so, the sentient-based right not to be harmed entails the right not to be killed. Now, though they don't say so explicitly, it seems clear from what they do say that they don't take these rights to be absolute, inviolable rights. Rather, they treat them as prima facie rights, rights that morally constrain us unless there are sufficiently weighty countervailing considerations that outweigh the right in question. As they put it, quote, absent some very strong justification, we have a moral duty to avoid inflicting suffering or death on any sentient being, whether human or non-human. When it comes to raising animals for food, there are no such countervailing considerations. Since we can easily meet all of our nutritional needs and can actually meet them better, and since we can satisfy our desire for tasty food with delicious plant-based meals, there is no good reason to subject animals to the horrors of factory farms, nor is there a good reason to kill them for food. Since we all agree that it's wrong to harm animals or cause them to suffer or kill them for no good reason, our own beliefs commit us to the immorality of raising and killing animals for food. So that's one of the things I find striking and important about their book. They're trying to force us to grapple with our own beliefs and commitments, and they're not trying to impose their values on us. They're trying to impose our own values on us. So anyway, as I see it, their argument for ethical veganism is extremely compelling and deserves careful reading. Since sentient fetuses also have the right not to be harmed and the right not to be killed, Sherry and Mike contend that aborting sentient fetuses is also morally wrong unless the pregnant woman has some very strong moral justification for doing so. What about presentient fetuses? As noted above, Sherry and Mike argue that aborting presentient fetuses raises no moral concerns at all, and they offer two independent reasons for this conclusion. So let's consider and assess each of these reasons. Their first reason for thinking that aborting presentient fetuses is morally benign is that presentient fetuses cannot be harmed. Lacking consciousness, presentient fetuses are, in their view, some things, not some ones. Thus, a presentient fetus cannot be harmed, they argue, because prior to sentience, there's no someone to be harmed. We might call this the who's the victim, or where's the victim concern. Well, is it really the case that presentient fetuses cannot be harmed? Grinding up live baby chicks harms them because it deprives them of a life worth living. Killing a normal, healthy, presentient fetus likewise deprives that fetus of a life worth living. If being deprived of a life worth living harms chicks, it's hard to see why it doesn't also harm a healthy, presentient fetus. Now, so that this discussion doesn't just wind up a clash of intuitions, let's consider our common sense understanding of harm. To harm an entity is to make that entity worse off than it otherwise would have been. More formally, we can define harm. For any X, action A harms X if and only if action A makes X worse off than X would have been had A not occurred. Now, it follows from harm, that definition of harm, that not all deaths are harms. The death of a terminally ill, incurable cancer patient racked with pain is not a harm. Every additional day that that person lives makes him or her worse off. Death in such a case is a relief. It's a benefit. And we can use this general account of harm to explain when death does harm animals. So I'll call this death. Death harms an animal to the extent that it results in that animal's life containing less net well-being than it otherwise would have contained. Aborting a normal, healthy, presentient fetus that would have had a life worth living results in that fetus having considerably less net well-being than it would have had if it were allowed to live. Conversely, carrying a healthy, normal, presentient fetus to term would bestow a benefit. That organism would be better off than it would have been had it been aborted. Any case where being born would confer a benefit is a case where being aborted would constitute a harm. If being born would make the fetus better off, then being aborted would make the fetus worse off. Now, independent of such conceptual analysis, it's also worth noting that most of us actually think that presentient fetuses can be harmed. A pregnant woman who drinks excessive amounts of alcohol every day the first trimester of the pregnancy and then stops all alcohol consumption harms her fetus by poisoning the fetus. When the baby is subsequently born with severe fetal alcohol syndrome, As a result of that drinking, it's clear that the pregnant woman harmed the fetus, and it's also clear that the harm took place prior to fetal sentience. It'd be strange to say that the harm did not take place at the time of the drinking, but rather took place months later after the fetus became sentient, since the damage was done at the time of the drinking. Okay. The second reason they offer for thinking that aborting pre-sentient fetuses is morally benign rests on the distinction between negative and positive duties. I'm sure all of you are familiar with it. Negative duties are duties to do no harm, whereas positive duties are duties to provide some benefit or assistance. Sherry and Mike draw on the distinction between acts and omissions to argue that we have a strong negative duty to refrain from harming any being capable of being harmed. It's clearly wrong to actively harm another being, but we have no positive duties to assist others. Failing to confer a benefit is perfectly permissible, unless we acquire those positive duties by voluntarily entering into certain kinds of relationships or agreements. Now, since they think that pre-sentient fetuses cannot be harmed, for the reasons I discussed above, they contend that aborting fetuses is just a failure to provide the benefit of being born. And since we have no positive duties to benefit others, a pregnant woman has no duty to benefit the pre-sentient fetus by bringing it to term. The supposed moral distinction between actions and omissions does not hold up well to philosophical scrutiny. Consider Peter Singer's famous pond example. On my way to give a lecture, I noticed that a small child has fallen into a campus pond and is in danger of drowning. If I wade in and save the child, I will ruin my pants and my shoes, and I may have to delay my lecture. Would anyone deny that it would be morally wrong of me to let the child drown? As I understand Sherry and Mark, they think my wading in to save the child would be an act of supererogation. Saving the child, though an incredibly good thing to do, is not morally required. Usually it's only utilitarians that have to bite such large bullets. My take on the pond example is that it would be profoundly morally wrong of me to let the child drown. And if that's right, then we do have positive duties to assist others in addition to the negative duties to do no harm. Moreover, my positive duty to save the drowning child becomes even stronger if I am the only person who can do so. So I'll let you think about the parallels between pregnancy. If, as I suggested above, pre-sentient fetuses can be harmed by their deaths, and if the capacity to be harmed in a certain way confers a right not to be harmed in that way, then pre-sentient fetuses, like their sentient counterparts, have a prima facie right not to be killed. Even so, it wouldn't follow that aborting them is always wrong, because prima facie rights are overridable. The woman might have an overriding reason morally weighty enough to justify the abortion. Let's just focus on sentient fetuses, since they clearly have the capacity to be harmed and the corresponding right not to be harmed. As I said before, Sherry and Mike hold, quote, absent some very strong justification, we have a moral duty to avoid intentionally inflicting suffering or death on any sentient being, whether human or non-human. Now, we're never told what sorts of reasons would be morally weighty enough to justify aborting a sentient fetus with a right not to be killed. Is the desire not to be pregnant weighty enough to justify killing a sentient being with a right to life? Is the desire for a child of a different sex? I suspect that they think that aborting a sentient male fetus because the woman wants a daughter instead would not be an adequate justification for terminating the life of a sentient being. That's something like desiring steak over seitan. But they don't give us a clear answer as to what sorts of reasons would be morally weighty enough. And here's why I think this is important that they do so. They maintain that some abortions are clearly immoral, but that the woman should still have a legal right to an abortion even when the abortion is immoral. They think the decision of whether or not to have an abortion should always be left up to the mother. Given our laws, it is up to the mother, it is up to the pregnant woman whether or not to have an abortion, at least within a certain time frame. But it's not up to the mother or the woman whether or not the abortion is morally permissible. Morality doesn't vary from individual to individual. So it would be very helpful, and particularly helpful for women, to know when an abortion is immoral and when it's not. what sorts of considerations adequately justify the procedure and what sorts of considerations don't. Now, they also argue that one of the reasons they think that there should not be laws prohibiting abortion is they think that such laws force women into reproductive servitude. They're in essence Good Samaritan laws, and they think that we shouldn't have such laws. Now, while it's true that only women can be subject to that kind of reproductive servitude, men can be and routinely are legally conscripted into another kind of reproductive-related servitude. The father of a single mother's child is legally required to pay child support for the first 18 years of life. Suppose he simply doesn't want to be in that kind of servitude. Would it be permissible for him to kill the one-day-old infant to free himself from such a burden? Surely not. If a man cannot kill an unwanted child to avoid 18 years of involuntary servitude, why is it permissible for a woman to kill a fetus to avoid 9 months of reproductive servitude? That's not an argument, it's just a question. Okay. Lastly, the last part of their book turns to tactics and strategies. So if you're convinced that animals have rights not to be abused in these sorts of ways, what are the most effective means to reduce the number of rights violations? If you're convinced that certain abortions are morally wrong and should be prevented, what's the most effective strategy or tactic to bring that about? So, assuming, as I do, that the ultimate goal is to bring an end to animal exploitation in agriculture and science, should animal rights organizations, broadly construed, work to improve the welfare of the billions of animals currently being exploited in the most grotesque, horrific ways, or should they only support approaches that get the abolitionist seal of approval, such as vegan education campaigns or funding vegan startup companies? Sherry and Mike offer a largely a priori argument for favoring the abolitionist approach that I can't rehearse here. And I don't have time to do the debate justice, but I'd like to make a couple of ecumenical observations. The first thing to note is that the debate over welfarism and abolitionism is that the two approaches are not mutually exclusive, despite what some parties would say. Many organizations that work to improve animal welfare also engage vigorously in vegan education. Second, those who oppose welfarism usually cite the worst forms of welfarism to support their case. When organizations work with the animal industry to promote some inconsequential change, and then in turn promote the sale of animal products so produced, those organizations betray the animals they were pledged to benefit. But organizations can work with state and federal legislatures, not the industry, to pass laws that ban and criminalize all unanesthetized mutilation. They can work with legislatures to completely ban gestation crates. And even when organizations achieve such goals, they should never endorse the new product as humane because the industry is still inhumane. Instead, the organization should immediately start working with legislatures to pass the next reform. Each of the reforms I'm envisioning will raise the cost of producing meat and animal products, and the higher prices will reduce demand, thereby reducing the number of animals being unjustly exploited. Thought experiment. If I were an unjustly held captive in Guantanamo, despite the wrongness of my imprisonment, I would be extremely grateful if the U.S. government criminalized all forms of torture. Okay. Graphic images. Should activists use graphic images in an effort to persuade others to adopt vegan lifestyles? Sherry and Mike think that, generally speaking, no, we shouldn't use such images. Now, here I actually do disagree as a matter of strategy. Having taught animal ethics for 20-plus years, I think it's critically important to show people graphic videos of the violence they're supporting when they consume animals and animal products. So let me explain why. There was some reference to Hume earlier. Hume famously quipped, "Reason is and ought to be slave to the passions." Hume was what philosophers call an externalist where moral motivation is concerned, and so am I. That is, an externalist believes that a person can sincerely judge that an action is wrong, can sincerely judge that eating meat is morally wrong, but feel no motivation whatsoever to change his or her behavior. Nearly every semester that I teach contemporary moral issues, I have the following sort of encounter with students. After reading and discussing Singer's and Reagan's arguments for ethical vegetarianism, students will come up to me after class and say, "You've convinced me. I believe that eating meat is wrong." Only to defiantly add, "But I'm going to continue doing it anyway." So there. The next class period, these same students meet their meat when I show a 12-minute video documenting the realities of animal agriculture. After viewing these videos, many of these same students come up to me after class and say, "I had no idea it was so bad. I'm never eating meat again. Thank you for showing the video." What changed? On day one, they believed that eating meat was wrong. What changed? On day one, they believed that eating meat was wrong. They had what I call thin knowledge of the wrongness of eating meat. They had some sort of knowledge that eating meat was wrong, but they did not fully grasp or understand or appreciate the wrongness. On day two, they not only believed that eating meat was wrong, they felt that eating meat was wrong. They acquired thick knowledge or full understanding of the wrongness of eating meat. And that was only conveyed by both appealing to their rational and their conative sides. We're not purely rational beings. We're not purely emotional beings. We're a rich complex of both. And so we need to appeal to the whole person when we make our arguments. Okay. One of the greatest virtues of Sherry's and Mike's book is that they never shy away from controversial topics. One such topic is violence. Should animal rights activists use violence to reduce the number of animal rights violations? The first thing to note is that we do think that some atrocities are so heinous that violence is justified to bring them to an end. When the Nazis embarked on their genocidal project and began implementing the so-called final solution, the Nazis were systematically violating the rights of millions of innocent Jews. Virtually everyone agrees that the Allies' use of violence against the Nazis to bring an end to their heinous treatment of Jews was indeed warranted. Some people in the animal rights movement view our current wholesale disregard for the rights of animals as the moral equivalent of the Nazi Holocaust. On their view, sentient beings have a right to life and a right not to be harmed. Since animal agriculture systematically violates their rights, Sherry and Mike explore whether it be morally permissible to use violence to protect the rights of at least some of these innocent victims. Their position, they equivocally and categorically oppose violence in both the animal rights movement and the abortion and the anti-abortion movement. But I'm going to focus on the animal rights movement. In particular, they oppose violence directed at perpetrators of rights violations, farmers and slaughterhouse workers. And they do so for two reasons. First, while it may be true that one can save some particular animals by an act of violence, there are other particular animals that one can save without violence. So why choose the violent method over the nonviolent method, especially when you're trying to further the ahimsa ideal of nonviolence? Second, they offer a consequentialist argument that violence is unlikely to be effective at reducing the number of animals victimized by the meat and animal product industries. In assessing the likely effectiveness of violence, they focus exclusively on violence directed at perpetrators of animal rights violations. They don't consider the effectiveness of violence perpetrated against consumers of animal products who are ultimately responsible for the miserable lives farmed animals are forced to endure. Even though such violence might be far more effective, in part because it could be done covertly. Suppose, for example, that members of the Animal Liberation Front started a campaign where they regularly contaminated animal products with E. coli or Listeria or Campylobacter, bacteria that they're often contaminated with anyway. No one would be the wiser. Tens of thousands of people would get seriously ill, and perhaps some would die as a result of these outbreaks. However, the demand for that particular contaminated animal product would decline dramatically. The demand for beef in England has never recovered from the mad cow disease scare of the 1990s, despite the fact that very few people ever contracted Creutzfeldt-Jakob disease. Now, I'm not advocating such violence, but I am curious to hear whether Sherry and Mike would support forms of violence that would, in fact, effectively reduce the demand for animal products and thus reduce the number of animal victims. Okay, closing thoughts. Let me conclude by thanking Sherry and Mike for writing such a wonderful book. As a commentator, my role is to look for holes in their argument. I had to look long and hard to find any holes, and the holes that I did find if they're really holes, did not affect their overall argument. Regardless whether they're positive duties or not, there clearly are negative duties not to harm any being capable of being harmed without adequate justification. Sentient fetuses and sentient animals can be harmed, so we have a duty not to harm them absent compelling reasons to do so. A pregnant woman might have a compelling reason to abort a sentient fetus, but there's no compelling reason to kill or pay others to kill animals for food, since we can easily meet all of our nutritional needs with a plant-based diet. Thus, as Sherry and Mike observe, the case for ethical veganism is much stronger than the case against abortion, even where sentient fetuses are concerned. Thanks.
Okay, thanks. It is a real pleasure and an honor to be here to share my thoughts about this very important book. By bringing abortion and animal rights into close conversation with one another, Professors Colb and Dorf managed to meaningfully advance our understanding of each domain, and this is really an extraordinary feat. Apart from my admiration at the insight animating the juxtaposition of these two seemingly inopposite bodies of law and morality, I too was struck throughout the book by the tremendous execution of its underlying premise, namely that given the moral centrality of sentience, we can learn a great deal about animal rights by thinking about abortion and vice versa. From start to finish, the book, as you've heard, is rigorous, it's fair, and it is grounded in everyday lives and experiences. I have to add what by now is obvious. This is difficult, fraught terrain, a reality that Professors Colb and Dorf candidly acknowledge. They treat their subjects with care, kindness, and courage. The book makes many fascinating contributions, more than we have time here to discuss. So I highly recommend that those who haven't yet read it do so. I am not a moral philosopher. I want to focus my remarks on what the book tells us about the law side of the legality-morality divide. On the one hand, Colb and Dorf tell a limits of law story, one that I find quite compelling. But the book also helps us to think about the real promise of law and of legal rights in particular, to promote social change under suboptimal circumstances. That is, a backdrop of deeply entrenched hierarchies. To see how this dialectic plays out, let's start with abortion. To briefly summarize the thrust of the argument, sentience is a sufficient condition for moral consideration. Under certain circumstances, a woman may have a moral duty not to abort a sentient fetus. Nonetheless, there are sound reasons to believe that the law ought not to prohibit that conduct. The most compelling reasons, it seems to me, not to involve the law are those steeped in norms of sex equality. After all, the authors note, laws criminalizing abortion convert moral duties of women into legal duties without converting comparable moral duties of men into legal duties. A woman's reasons, whether sympathetic or not, for wanting to terminate her pregnancy can be less important than her interest in opting not to carry the fetus to term. One of the many helpful interventions by Professors Colb and Dorf is to observe that if technology someday progresses to the point where a woman can terminate a pregnancy safely without killing the sentient fetus, we might well think differently about the right, such as it is, of the sentient fetus to live. Until that time, however, a fetus's continuing existence depends entirely on the pregnant woman. Well, this thought experiment suggests a theme that runs throughout the book. Rights, and again I want to focus on the law, so legal rights, possess a relational quality, one that is too often obscured by dominant discourses. Recognizing a fetus as a being with legal rights, for instance, or as a person, has profound implications for the woman carrying it. And not just for relations between women and their fetuses, but also for relations between women and men. Colb and Dorf powerfully illustrate how a woman forced to continue a pregnancy endures a form of conscription. And they show how the sexual servitude of women, much like the sexual servitude of farmed animals, cannot but undermine sex equality. We might also observe that affording legal status to a fetus has had effects even outside the abortion context. The legal severing of a fetus from the pregnant woman has generally resulted of a pitting of her interests against those of the fetus. In essence, the relationship has been constructed within the law as adversarial. Over time, this move has increased the state's power to interfere in the lives of pregnant women. Pregnant women, disproportionately African American and low income, have been prosecuted for using drugs, refusing a cesarean section, having sex outside a doctor's recommendation, and attempting suicide. Fetal rights, in short, have pervasive equality implications for women that ought to be considered, as Professors Colb and Dorf point out, when we assess the proper role of law in regulating abortion. So before turning to animal rights, I want to say just a bit more about the idea that the law should perhaps not intrude, even where a woman's decision to abort is immoral, in large part because only women bear the consequences of state intervention. Again, women as a group are further subordinated by this type of legal intervention. But I want to raise a question about whether our judgments about the rightness or wrongness of particular decisions to terminate a pregnancy should be embedded in an awareness of this same social context. My thoughts here are tentative, but I do wonder whether, even granting that a sentient fetus deserves moral consideration, we should condemn a woman who chooses to abort. And I wonder this not simply with regard to rape and incest, but even to less sympathetic cases, cases involving economic constraints, or even, let's say, professional ambition. I find it interesting that record numbers of doctors are pursuing expertise in performing abortions, and that women individually and collectively are resisting stigmatizing moves, in part to counter opponents' legal strategies premised on abortion regret, to be sure, but also, it seems to me, to alter the social conditions under which abortion is accessed. For just one example, consider the hashtag #ShoutYourAbortion, the social media movement aimed at breaking the silence surrounding abortion in this country. According to the woman who created the hashtag, a shout is not a celebration or a value judgment. It's the opposite of a whisper, of silence. Even women who support abortion rights have been silenced and told they were supposed to feel bad about having an abortion. That's the end of the quote. I see this really as a plea not to be judged. Professors Colb and Dorf have given us a wonderfully rich framework for evaluating this nascent movement on the part of abortion rights activists outside of law, really to transform the meaning of abortion. So what about animal rights? The case for recognizing not just moral but legal rights is a strong one. Colb and Dorf. While a woman seeking an abortion seeks to vindicate her interest in terminating a physically demanding occupation and use of her body and organ systems, a person seeking to consume animal products seeks only to vindicate an interest in consuming the flesh and secretions of sentient beings. In other words, the interest of the pregnant woman is in terminating her own exploitation, and the interest of the consumer is in perpetrating the exploitation of another. Yet having mounted this powerful argument for applying the sentience criterion to members of reasonably complex animal species, and having effectively undermined necessity-based rationales for consuming animal products, with the possible exception of a medicine that is the product of animal testing and contains animal ingredients, Colb and Dorf reject the idea that most exploitation of animals should be legally banned. So why not ban meat, leather, dairy, and eggs? One answer offered is that a legal ban is simply not feasible in terms of passage or enforceability. Upwards of 98% of the U.S. population consumes animal products. Our reliance on animal exploitation is exceedingly difficult to dislodge. Indeed, it would be difficult to overstate, I think, the cognitive dissonance involved in accepting that a practice that most of us have engaged in throughout our lives that those around us engage in without compunction is morally wrong. This is, at its core, I think, a problem of what Margaret Radin has called bad coherence. It is also a tension that recurs whenever social justice movements seek to challenge a largely accepted status quo, particularly one deeply entrenched. The law can advance change, to be sure, but it may be of limited utility where widespread social norms lag too far behind the desired endpoint. With this recognition front and center, Colb and Dorf offer a provocative analysis of tactical considerations confronting the movement for animal rights. How do we get from here to there? Again, a familiar dilemma surfaces. Can partial measures bring about meaningful progress, or do they further reify existing arrangements of power? More specifically, if you believe in the abolitionist approach to animal use, should you support welfarist measures aimed at reducing suffering? The argument for the welfarist approach is relatively straightforward. In the short term, the suffering of animals will be reduced. All the while, attitudes will change, and we move ever closer toward the day when abolition is politically feasible. In the end, however, Colb and Dorf conclude that reforms aimed at animal welfare are misguided, and their reasoning beautifully captures how tactics and principles are intertwined. The problem with animal welfare laws, for instance, laws regulating cage sizes and access to fresh air for farmed animals, is that such laws reinforce the pro-animal exploitation narrative. Measures aimed at reducing suffering, in other words, are fully consistent with a regime that tolerates massive animal death and utilization, albeit achieved in the kindest, most humane ways possible. For those who believe that animals should never be killed for our uses, this half measure begets conceptual incoherence. Must the law remain sidelined, then, while widely practiced patterns of immoral conduct rage rampant? The answer given is no. But here again, the reach of law ought to be limited. In Colb's and Dorf's view, incremental reforms not grounded in a pro-exploitation framework are the best way forward. Without accepting that animals should ever be exploited, we might, for example, adopt regulations that facilitate veganism. Prisons and public schools should offer vegan options, as should communal events like this one. For those of you who chose the chicken salad, it was indeed vegan chicken salad. We might also reduce governmental support for animal exploitation, support that includes farm and industry subsidies that lower prices for animal products. Okay, all of this seems like an eminently sensible, even wise agenda for reform. Still, I was left wanting perhaps more law. To mitigate suffering, what would be the effects of creating legal rights to be free of cruelty, along with enforcement mechanisms to make real their promise? In all likelihood, given the imperatives of mass production, might robust legal regulation in this arena and its associated costs have the effect of curtailing supply? Maybe. More directly to Colb's and Dorf's concerns, might such a movement change our very relationship to animals, such that if the day comes that we have alleviated animal suffering, if we see animals as beings with a set of real moral interests, might most of us no longer want to eat animals? In the end, the promise of legal rights is, after all, that they alter relations between those who have newly been given these rights and those who have long possessed them. To close, I want to offer the rather utopian hope that a legal movement aimed at eliminating the suffering of sentient animal beings could cause all of us to become newly attuned to human pain in our midst throughout the world. That said, Professors Colb and Dorf persuade me that, at least for now, the greatest push for animal rights may come from outside the law, from education, or consciousness raising, if you will, in the choices that each of us make in order to live as best we can. The book makes abundantly clear that decision-making about animal rights, like decision-making about abortion, is imperfect and that it occurs in an unjust world. This is of course, true. Still, work like Beating Hearts can undoubtedly help to mend this damaged world, and I thank you for it.
First thing I want to do is to thank the people up here and the people out there for being here and for putting time into it. Brad, thank you for your all of you actually, thank you for your very generous words about our book. It was a labor of love to write the book, and it's wonderful to see it received so generously. So thank you, and thank you to Cornell, I guess, to name a non-sentient, for providing us with the opportunity to write the book and to talk about it today. So Mylan, so you posed a lot of questions, a lot of tough questions, and so I'm going to try to answer some of them, and then Michael will try to answer others, but I'm sure we will end up leaving some questions unanswered and leaving you unsatisfied, so just to warn you in advance. So the question about pre-sentient fetuses. So Mylan raises the question of whether a fetus that is not yet sentient can be harmed, and he answers the question, yes, can be harmed. And he gives a very interesting example of it. He says that if a woman is pregnant and she's in her first trimester when drinking alcohol has the greatest impact on a fetus, and she drinks a lot of alcohol and she stops after the first trimester, so by the time the fetus is sentient, she's no longer drinking, and then she gives birth to a baby with fetal alcohol syndrome, she has harmed, he says, she has harmed that she harmed the fetus at the moment that she took the drink. And I would quarrel with that characterization. What I would say is that she set in motion the conditions for that not yet sentient being to be harmed later should she take the pregnancy to term. And the analogy I would give, I would say that perhaps if her plan is to give birth, that perhaps the culpability and the action is already in place, but the harm has not yet occurred. Much in the way that if I put together a bottle of poison and place it in someone's coffee cup and then place that coffee cup on their desk. I'm thinking of examples from criminal law. And then the person who's about to enter that desk comes in and later, let's say a week later, and drinks it and dies. The harm happened at the moment that that person drank the poison, I would say, not at the moment that I placed the cup there, that my culpability has been established already, and that the whatever condemnation one wants to heap on me would be appropriate at that moment. We'd say an attempt has happened, in the words of the criminal law, but there hasn't yet been a harm, there hasn't yet been a result. If someone should interfere, will take the poison away, or the person doesn't drink it, or whatever, and that doesn't happen, then there is no harm. So I would say that it's difficult to say that we've harmed the presentient fetus when we don't even know yet whether there will or will not be a harm. That the harm is at that point what we would call inchoate. It hasn't yet occurred. And so what we really have is an inchoate crime against the fetus, if we want to place it that way, and it may never come to pass. To give you an analogy, because Mylan mentions that if we kill the presentient fetus who would have had a great life, or that would have had a great life, then we are doing a harm. But one could say, I could take any one of you and say, you know, if you have a child in 9 months, that child would have a great life. So you are doing a harm against the potential child that you are not currently conceiving instead of being here at this event. Because that child would have had a great life. And maybe the child would have had a great life, but I don't think we would say that you are committing a harm against anyone, because there's no one there. And our claim is that there is no one there yet at the point when a fetus is pre-sentient. So that yes, and I think I need to say a mea culpa about some of the language we used, because we said that a woman bestows a gift, and I think that that's where the language invites this critique. So if you're bestowing a gift, you must be conferring a benefit on the presentient fetus. So I think I would say that maybe we should have used different language rather than saying bestowing a gift, because in a sense, to create the gift recipient and bestow the gift at the same time is a sort of an oddity. And that maybe it is better to say that once someone comes into existence, it's possible to say that we have harmed that someone by creating them if their life is full of suffering and pain and terrible. But that even if they have a good life, it isn't really possible to compare their good life with non-existence, with their never having come into existence. It's not that, oh, they would have had a low welfare life versus a high welfare life, but that there's non-existence versus a high welfare life. There isn't really the opportunity or the space to draw a comparison there. So I would say that maybe we misspoke in a sense of saying bestowing a gift to the extent that that means conferring a benefit. You know, and in the same way, whenever people don't have children, one could say that they have harmed all of those children that they didn't have, and yet we don't speak that way. We don't say every sperm is sacred in that particular way, and so that, oh, look at that sperm that could have been a very happy person, and that we view ourselves as committing a crime against it. I don't think we think of it that way, and that's how we conceive of the pre-sentient fetus. We agree that death is not always a harm. So that is not that sometimes death is a benefit. So that we wouldn't disagree with that. Okay, other things. Act omission. Okay, so I think we agree that if we're walking somewhere and we're in a hurry and then we see someone drowning and we decide, well, you know, I really need to get to cite something that I wrote at another point, we really need to get to the bookstore to buy Atlas Shrugged, so we're not going to save this person who's drowning. I think we can all agree that there's a moral problem with that choice. So I don't think we're suggesting that omissions are completely free of moral judgment, but that there's this huge, vast difference between an act of violence and a failure to rescue. And I think our law reflects this. Well, our law does reflect this, that if you don't rescue someone, you don't get into as much trouble or any trouble. And I think our intuitions also reflect this, so that when we learn that somebody had an opportunity to help somebody, that even if we judge that person, we judge the person who did the actual act of harm more harshly. And that's to some degree what we're trying to capture with the act-omission distinction, and why we say that the harm of supporting the torture and slaughter of animals is categorically different from a failure to rescue, and why we say that it's a kind of paradox that people will rescue an animal and keep that animal in their home and do all sorts of really kind things for that animal while simultaneously committing grave harms against others. That there's something very odd about that, and we would see it as equally odd if someone were to be very active in opposing domestic violence, but at the same time rescue lots of people from domestic violence and simultaneously commit that in his or her own home. Okay. Then, comparing the man who has been conscripted into paying child support. So I think, as you might predict, our answer would be no, the man doesn't get to kill the baby because he doesn't want to pay child support. So that's probably not a surprise. There was no cliffhanger there. But I think part of why that is that the obligation to pay money is not, we don't think is comparable to the obligation to house someone inside one's own body. That kind of bodily integrity is categorically different. And it's reflected in part by our whole sort of division between criminal law and civil suits, where only money is at stake. We have a preponderance of the evidence standard typically, and you go into court and it's not treated, and you can do things like force O.J. Simpson to testify, which you can't do in a criminal case. And I mentioned that very old case because it was recently on television, just so you know. It's not one of my usual references to movies from the 20th century. Managed to forget my train of thought. So So the idea is that when bodily integrity is involved, such as in the criminal law and such as in pregnancy, that we have a very different approach, and we ought to have a very different approach to where only cash is involved, and that we allow someone to terminate their own physical conscription in a way that we rightly don't allow someone to terminate their financial obligations. Then, as far as banning all anesthetized mutilations, I think we would favor that. I don't think it's at all realistic. And I think I guess our judgment, and it's an empirical judgment, is that making actual differences in the lives of animals, substantially increasing their well-being through legislation, isn't a realistic option. Because so long as consumer demand remains static, that will keep the numbers of animals the same, and there simply isn't space on this planet to give them lots of space and so on, so that it's not really a physically possible. It's too expensive to anesthetize the animals before doing things to them. And at a deep level, as a philosophical matter, I think if one's job is to hurt animals, it is very difficult for someone at the same time to be very caring and nurturing towards that animal, that it's very hard to keep those two objectives in the same person. And so I think that's a fundamental problem with asking people whose job it is to prepare animals for slaughter to be kinder to them than they are. And so what we see is actually the opposite, that in fact we have very minimal laws regulating the treatment of animals on farms, and that they are, in fact, not honored, even those very minimal laws. Whenever there are inspections that are not planned and calendared, and inspections of places that are committed to animal welfare, supposedly, like Whole Foods, and their farms are investigated, and it's just horrible what's found there. So I guess yes, I think we would be in favor of real benefits on welfare, ending torture, and so on, but we don't view it as realistic, and it's an empirical judgment. As to, okay, why not go after perpetrators? Okay, so the question is, why not poison the meat supply or something like that? And so I whispered at that moment to Michael that actually we don't need to do that because it's already poisoned. That in fact E. coli is already there, so no one need act in order to do that. In fact, there's so much E. coli that it ends up in spinach, and people say to me, spinach, that's where you find the E. coli. And it's like, well, since spinach lacks a colon, one needs to understand that comes from somewhere else, not from the spinach plant. Okay. But a reason why we would not want to go after the perpetrators is that we were perpetrators. So I think part of it is not so much an answer having to do with efficacy, but having to do with humility and understanding that we were there too. And so we are not prepared to then, as soon as we become enlightened, to turn around and start being violent to people who are not yet there. So that I guess would be at least a partial response to that point. Am I done? All right, sure. So I guess I'm done, but I didn't say anything about what Deborah said. Okay, so you'll talk about Deborah. Okay, so let's see if I. Okay, so first I want to say thank you, Deborah, for a very generous reaction to our book. And I agree with what you say about being less judgmental of women who are pregnant. So I'm moved by that point, that maybe we should not only be less willing than we are to criminalize what women do when they're pregnant, but also be a little bit more understanding and less judgmental. And I think that that's true. And we try to capture that a little bit by saying that, by comparing a woman who has an abortion for bad reasons or for reasons we don't regard as very good reasons, to a woman who says no to a potential partner who wants to have sex for bad reasons, let's say because she's, doesn't like the race of the person or something like that. And that even as we think that the woman is making a choice that has moral problems to it, we would never compel her to make a different choice, and we would still regard what's happening to her, if she's in fact in that situation, as a serious infringement of her bodily integrity. So we don't mean to suggest that we take lightly her status. And you want to talk, so okay. So with that, I will turn it over to Michael. Thank you.
Okay, I'll try to be brief so we can get to questions before people have to zip out. So first I want to echo Sherry's thanks to our guests coming from Chicago and the state of Illinois, to Brad for moderating, to all the people we thank in the book, some of whom are in this room, and especially to Stuart Schwab and Eduardo Peñalver, who were the deans during the time we've been here, who've been very supportive of this work, which is, you know, it's good to have tenure because, you know, we say things that I think are somewhat unpopular occasionally, and they've been very supportive. Okay, so I want to begin by disagreeing with Sherry, who thought we were sloppy in the use of the phrase bestow a gift. So I'm going to read the relevant passage. So here's it. A presentient fetus has never been a someone. Thus, for a woman to gestate the presentient fetus past the point of sentience and then give birth to the resulting infant is, in an important sense, to bestow a gift. So you might think, aha, you're bestowing a gift on someone. But then look what we say right after that. It is an odd sort of gift, to be sure, in that the giving of the gift of life simultaneously creates the recipient of that gift. So there, I think we were not at all sloppy. Okay. Next. I want to talk very briefly about Brad's very generous and then somewhat challenging introductory remarks. And I essentially want to endorse what I took to be Mylan's response to Brad's comments, which is to say that we do think that rationality is an important characteristic of most, though not all, humans. And it is relevant to not only to the duties that rational beings have, but to the duties that are owed to rational beings, right? So that, for example, there can be agent-relative duties to people in our care in virtue of that rationality. Just give a concrete example. If you have children, you have a duty to educate them, right? So we have 2 daughters. We also have 3 dogs. I think we have a duty to pay for our children's education. It would be strange to say we have a duty to send our dogs to college, although anyone who's met our dogs would say we probably have failed in our duty to send them to obedience school, which is not true. We did send them to obedience school. We just didn't do any of the follow-up that we were supposed to have done. But in any event, right, the idea is that, yes, rationality is relevant to some things, right? If believing in animal rights doesn't mean that you believe that squirrels should have a right to vote, right? It means that you have a right to the sort of thing appropriate to your capacities. And so we agree. I think we would endorse what I took to be Mylan's response to the concern that Brad raises. Now, with respect to some of the points Mylan raised, I think that I largely endorse Sherry's response. I just want to add 2 things. One is that the act-omission distinction is fundamentally important to making it possible to live your life in a developed country. Right? If you think about, if you don't think that the act-omission distinction is important, then you really have no good reason for not giving away virtually all of the things you have, because given the enormous disparities in standards of living across the globe, and the decreasing marginal utility of wealth, even if there's some serious inefficiency in the transfer, you would do a lot more good by giving away your stuff to people in desperate situations in developing countries. And none of us thinks, well, some people think they're under a duty to do that. Virtually nobody does. And we think that ought implies can. That is to say, that moral duties oughtn't to be so demanding that people can't sort of live their lives in accordance with them. And that's not to say we don't have affirmative moral duties to people elsewhere, but we think that the law and conventional morality, and we are, as Mylan says, we are fundamentally appealing to shared moral premises, understand that we permissibly draw distinctions between what we do for people and what we do to people and other beings, right? So, again, how is it that we justify having social welfare programs for people in our country or doing things in our community? Each of these is based, we think, on the view that it is permissible to do more for those who are more like us, part of our community, etc., than those who are more distant from us, even though, of course, it's laudable to care about those who are more distant. But conversely, we wouldn't say it's therefore okay to go then round up, capture, and enslave people living in other countries, even though, of course, for much of human history, that's what was done. Okay. The second thing I want to say is, in response to Mylan, is basically to invoke, just as I invoked Mylan to respond to Brad, I want to invoke Deborah to respond to Mylan, which is so, it's true that we don't go into much detail about the sorts of reasons that we regard as good and bad for an individual woman making an abortion decision. I think we imply some of them. So we think sex selection abortion is not a good reason. We think sort of what is sometimes called mere convenience is not a good reason, right? That is you sort of procrastination. But I think the main reason we didn't want to spend a lot of the book sort of telling women, here are good moral reasons, here are bad moral reasons, in the way that we sort of do with respect to how we think people ought to interact with animals, is because of the sort of principle of humility, which Sherry pointed to, and I think the way that Deborah put it, which is that women who face a decision whether to have an abortion do take these questions very seriously, and vegans are constantly being accused of being judgy. So we're trying to avoid that kind of judgmentality. It's not to say we don't have views on it and we mightn't develop them. It's just we thought it more important to establish the principle that there needs to be these reasons, and that going much more into that would have a kind of preachy quality. Okay. Finally, I want to say one more thing about the sort of the so-called welfare versus rights debate. And I want to quibble with one characterization of our position. So, Mylan, I think you said that our position on this is a priori. I don't think that's right. I think our position is that it's empirical. But let me say what the "it" is there. So the way we frame the question is, if you are persuaded by the moral case that we lay out here and that others have laid out in other places, including Mylan, including Sherry in her most recent prior book, right, if you are persuaded by the ethical case for veganism and you want to go beyond personally refraining from what you believe is wrong conduct, but you want to influence the rest of the world, how ought you best to go about it? And so the question is, would it be a sensible use of your time to choose this, that, or the other mechanism? Now, one thing we don't say is we don't ask, from the perspective of the movement, what ought you try to do? That's just not the way things work, right? All social justice movements are diverse. There are people working different ways. It is inevitable that there will be a lot of people who are going to be working for the enactment of welfare laws and other measures, and we're not opposing that. So for us, the question is, what is the most sensible use of our time as activists? And there we worry about two things. One is that it might not be especially effective to pursue the welfare measures, at least given the current state of the world. Although we think, as I said, we think it is an empirical question, and it's an empirical question that is incredibly complex. It's like a question of, did Bismarck forestall communism in Europe, right? That's an empirical question. It's just very hard to answer that empirical question. And just a similar one, right? That is sort of, does meliorism prevent radical change, or does it pave the way to it? The answer is yes, no, sometimes, hard to tell, right? But we do think that's an empirical question, and so that's part of it. But the other question is, what do we want to do with our time? And there we think that for us, the more authentic way to be advocates is to advocate what we really believe, and so there's a kind of principled ground there. But we agree that ultimately on the question of whether welfare measures are the kind of incremental measures that would bring us to something like abolition, right? In the way, say, that you might have thought civil unions paved the way for same-sex marriage, right? We think it's conceptually possible, and we think it's an open question, and we're not, and we hope it does, because there's a lot of that going on out there. Okay, let me finally especially say that I want to endorse all of the nice things that the people said about our book and agree with those.